Hello, everyone. Welcome back to the Carly P. Riley Show. On today's episode, we are talking about how in the world is it possible that Sullivan and Cromwell is the law firm that has been allowed to shepherd, steward, run, control the FTX bankruptcy process. If you don't know what I'm talking about, I am going to explain this, but this is a hugely scandalous thing in my mind that is not getting enough coverage. Now, if you are new to the show, you may not know, I covered the Sam Bankman-Fried trial pretty closely here in New York back when that happened in November of last year. I've been in crypto for the last 2 years, so I've been following this story very closely. And this to me is the most interesting part of this whole situation that is not getting covered. There's plenty of things that are interesting about FTX. Most of them have gotten a lot of coverage. This one, it feels like it deserves more attention. So the basic premise here is Sullivan and Cromwell is a big law firm. They worked very closely with FTX US, though they have said they didn't. We'll talk about that. They worked very closely with FTX US while FTX was a functioning, up and running exchange, and they were permitted to stay on as the law firm that is running the bankruptcy, which is very strange, very unusual. It's very weird that a law firm that worked with a client who ended up convicted of fraud would then get to run the process post-fraud. For obvious reasons, that is a weird conflict of interest. For one thing, there's a question of, does this law firm have any culpability in the fraud? And if they're continuing to run the process afterwards, could they be covering up for any of their culpability? So the basic premise here, they should have known that something illegal was going on, or they did know that something illegal was going on. When everything's collapsed, they got worried that it was going to be revealed that they knew that, so they wanted to control the narrative. They wanted to control everything. They took control of the company from Sam under false pretenses. They have proceeded to make a crap ton of money on this bankruptcy, and by being the law firm overseeing this bankruptcy, as well as getting to cover their own asses. And they have done all of this at the expense of the FTX creditors, so FTX customers, who of course are the ultimate victims in this whole situation over and over and over again. So that is the basic premise of what we're going to talk about today, and I will certainly leave it up to you as the viewer to come to your own conclusions about all of this in the end. All right, I am not going to go into the FTX backstory. I just made reference above to the fact that FTX was commingling customer funds with their own funds. If you didn't know about any of that, I would start further back on this story. I have a whole playlist you can go check out covering the trial in which we get into a lot of what happened at FTX. This is not one of those episodes, or it would be a 10-hour long episode. So we're not going to talk about the FTX collapse, though I'll make reference to things about it throughout this episode. The last time I made an episode on this topic about Sullivan and Cromwell, like I said, I did it at the end of last year, and I really focused on the fact that Sullivan and Cromwell had told a judge, as part of their arguing for the fact that they should be allowed to control the bankruptcy process, they had told a judge that they had not really worked very closely with FTX. And that, they had done particular matter work. That was the phrase, particular matter work for FTX prior to its collapse, which means there were some discrete things we helped them out with, but it was really minor. We weren't really that involved. And I talked in the last episode about how seemingly strange that claim was and seemingly untrue that claim was. I mean, you had Sam Bankman-Fried, but you also had somebody else who was senior at FTX who remained anonymous. Both spoke to the Financial Times and said that Sullivan and Cromwell was the primary attorney for FTX US prior to its collapse. The primary attorney. Sam Bankman-Fried apparently worked out of the Sullivan and Cromwell offices oftentimes when he came to New York, because he was based in the Bahamas. And then the big thing that I really talked about in the last episode that I still think is striking is Sullivan and Cromwell billed FTX US for $8.6 million for work that they did over the course of about 72 weeks. And if you do the math on that, I can't remember the specifics of it now, but it's something like even if they were billing FTX at the partner rate, at the most expensive rate they could bill FTX, which is $2,000+ an hour or whatever, $8.6 million in billing would still mean that Sullivan and Cromwell did over 50 hours of work a week for FTX for over a year. Now that's an oversimplification because they didn't actually just bill hourly, they billed in other ways. But even when I get into more of the details, which I do in the past video, I won't summarize it all here, it doesn't look any better. It doesn't make the claim that Sullivan and Cromwell just did a little bit of work for FTX here and there. It doesn't make that claim any more reasonable when you dig into the math on what they billed FTX over the course of 72 weeks. Okay, that's what I talked about last time. What I didn't talk about was a company called LedgerX. And LedgerX is really important to this story because it becomes the link that potentially, or in my opinion, clearly ties Sullivan and Cromwell to nefarious behavior that would give them the incentive to cover their own asses and control this process in the way that they have done. So LedgerX is very important to this story. Now, LedgerX is a company that was founded back in 2013, another crypto company, and it had gotten some key licenses, some key approvals, regulatory approvals within the United States to operate like futures market, options trading, certain kinds of trading within cryptocurrency that most other exchanges, most other firms could not do. You had to get these licenses in order to do this. And so FTX acquired LedgerX in 2021 as a way for FTX to get these kinds of licenses. They're basically acquiring them such that they could inherit the licenses to allow for this special kind of trading. FTX's very reasonable logic being that it would give FTX, the exchange, a huge advantage in the US. And we're talking about FTX US specifically here. It would give them a huge advantage to have some of these licenses. Now, it gets a little complicated. I mean, there were more licenses that they wanted from the CFTC. So it wasn't like they acquired LedgerX and everything was done, and that is a part of the story. But they acquired LedgerX in 2021. Now, Sullivan and Cromwell was the law firm that oversaw that acquisition of the FTX buying LedgerX in 2021. And Sullivan and Cromwell continued to be the law firm that managed everything to do with LedgerX, and specifically was the liaison between LedgerX and FTX, which is now the same company because FTX owns them, but was liaison between them and the CFTC. The CFTC is the regulatory body that approved these variety of licenses that FTX wanted, and FTX was still in the process of applying for even more licenses from the CFTC, and all of that was being run and managed by Sullivan and Cromwell, who are known as being a law firm with good relationship with regulators and is this being an area of expertise for Sullivan and Cromwell. Now, in the summer of 2022, FTX responded to a series of questions from the CFTC, clearly as part of this application process, is trying to get regulatory approval licenses process. FTX responded to a series of questions from the CFTC, LedgerX, FTX. I'm sort of using that interchangeably in this context. And now we don't know exactly what Sullivan and Cromwell did as part of this process, but ultimately an email response that was sent to the CFTC seemed to come from a man named Colin Lloyd, who was a Sullivan and Cromwell attorney. So, and again, clearly, this was what Sullivan and Cromwell did for LedgerX and FTX. One of the things that we know they did was to coordinate with the CFTC. This was their ballywick, right? This is what they did. And so in this article by Jonathan Lipson and David Skeel, they talk about this. And they share a screenshot, an image of part of an email response from seemingly this guy, Colin Lloyd from Sullivan and Cromwell, representing FTX and LedgerX, to the CFTC. And in that email, it says this. It says, and I'm going to explain this. If you're a little bit confused by this, I will explain it. This response says, Alameda Research is one among many other professional trading participants transacting on both FTX International and FTX US. In both instances, Alameda Research has no preferential fee structures or special or unique access to the exchange, to exchange data, or to any other feature of either exchange versus that which is available to any other professional trading participant. So what this email is saying in response to questions that had been submitted by the CFTC is that Alameda Research has no special privileges, no special access to FTX. Now, folks who have followed this case for a while already understand that this is wrong and are probably already are 2 steps ahead of this. But just for anybody who isn't been following along, Alameda Research was a hedge fund, a crypto hedge fund that was started by Sam Bankman-Fried before he then started FTX. And it is key to the whole collapse of FTX story, because Alameda Research could borrow unlimited money from FTX, the exchange. They were spending customer money. I mean, it was the messiness of this whole corporate structure and the way in which the participants treated money that was Alameda's versus customers versus FTX's as essentially fungible, interchangeable money was the problem. And Alameda very much had special privileges and special access on the FTX exchange. So this email, seemingly sent by a Sullivan and Cromwell attorney, is saying something that is not true to the CFTC. Now, this is how Jonathan Lipson and David Skeel talk about it in their paper. They say, quote, "It is not clear what role Sullivan and Cromwell played in preparing this response, although it appears that Lloyd sent it." Again, that's the Sullivan and Cromwell attorney. "It does, however, indicate that the CFTC licensure application process may have exposed Sullivan and Cromwell to the linkages that led to Alameda's significant obligations to FTX trading and the commingling that was central to the misconduct at the time." This last sentence is especially key to me. If Sullivan and Cromwell did not know of such linkages, then it is not clear how it could have represented that, in effect, they did not exist. There's like kind of two scenarios here. Either Sullivan and Cromwell knew what they were saying was not true. Right? They knew that there was this link between Alameda Research and FTX that went beyond what was normal, in which case they lied to the CFTC, and that's like obviously a crime and needs to be looked into, and like that's a whole problem. Or they hadn't bothered finding out if there was these special linkages, in which case, how could they so confidently say to the CFTC that those linkages, that this special relationship didn't exist if they hadn't bothered to really try and find out? Now, of course, there's the option here, which is, I'm sure what Sullivan and Cromwell would say, which is like, well, we were told that there were no special privileges by Alameda, so we just represented what we were told, which sure, and that's certainly the most benign version of all this, and maybe the true one, although there's reason to believe that Sullivan and Cromwell did actually know about the special relationship, and we'll talk about that in literally just a second. But that also still doesn't look good for Sullivan and Cromwell. Sullivan and Cromwell is like A+ premier, elite, top of the top law firm specializing in these regulatory issues. The idea that they just accepted at face value something that they were told that is pretty material and important to this application to the CFTC, like it still doesn't look good for them. And so again, any level of this impropriety, from the lowest level of impropriety to the highest level of impropriety, still to me gives them an incentive to want to continue to control this process, to cover their own asses, right? Regardless of whether or not that's what's actually in the best interest of FTX creditors. But there is reason to think that Sullivan and Cromwell actually did know about the backdoor, the special relationship between Alameda and FTX. Because it turns out in 2022, a whistleblower within LedgerX noticed that the code base allowed for unlimited borrowing, essentially, from Alameda, by Alameda from FTX. And this coder, or whoever discovered this, told their boss, who was a woman named Julie Schoening. Now, Julie supposedly brought this to Zach Dexter, a gentleman who's interesting in all of this as well. Zach Dexter was the CEO of LedgerX. So we've now gone up the chain of command, and the CEO of LedgerX has been told, hey, there's this really strange piece of code that allows Alameda to unlimited borrow from FTX, and that seems weird and it seems wrong. A few months later, Julie Schoening is fired. Now, this, like many parts of this story, as you'll see, we don't know what happened. LedgerX has claimed that the firing had nothing to do, or FTX or people have claimed that it had nothing to do with the fact that she had seemingly blown the whistle on this. And yet Julie threatened to sue LedgerX, and LedgerX, FTX, again, they're one and the same at this point, FTX settled with Julie. Unclear if she was ever actually paid anything, because then the company collapsed a few months later. But like, point is, something strange happened with all of this. And most importantly, it was raised to the highest level of LedgerX, to the highest level of LedgerX leadership within FTX, that this relationship existed. And Sullivan and Cromwell were the attorneys overseeing this whole thing. Now, Ryan Miller, who was and I'm sorry, I know there's a lot of names, who was the senior most, he was like the senior most legal counsel for FTX US. He was formerly a partner at Sullivan and Cromwell. So again, the ties between Sullivan and Cromwell, LedgerX, FTX run very deep. And it is very hard for me to imagine that when Julie Schoening came to Zach Dexter and told him this information, that he did not then talk to the attorneys about this. Also, if you have dug into this case a lot, which I've done, and you've read a lot of, like, there was a very close relationship between Zach Dexter and Ryan Miller and Sullivan and Cromwell. In fact, when everything was collapsing in November of 2022, Sam Bankman-Fried ultimately signed an agreement that gave power over to essentially Sullivan and Cromwell. And it was the Sullivan and Cromwell attorneys and Zach Dexter who primarily were putting a lot of pressure on Sam to sign the power, like the company over essentially, to Sullivan and Cromwell. So these are very interconnected people. So it is very hard to believe that it never crossed anyone at Sullivan and Cromwell's desk that this woman, Julie Schoening, who also, by the way, was fired and then sued. So obviously the lawyers were going to be involved, even if it was like later on during the suit, like that they never found out that there was kind of this whistleblower situation. It completely beleaguers belief, in my opinion. But it gets weirder. We're not done with LedgerX and just how weird LedgerX is within the broader FTX universe. Because in early November, FTX is collapsing. Sam Bankman-Fried, CEO of FTX at the time, signs essentially an omnibus agreement, basically gives full power to a man named John Ray III to take over FTX. Again, people who are following this case will know this well. They'll know John Ray III well. John Ray III was the person that Sullivan and Cromwell recommended to Sam. Sullivan and Cromwell told Sam, hey, you should sign the company essentially over to John Ray III. Sam ultimately does it. John Ray III then immediately appoints Sullivan and Cromwell to be the counsel for the bankruptcy. Very you scratch my back, I'll scratch your back, or whatever the heck. Within hours of Sam having signed this agreement, giving power over to John Ray III and John Ray III appointing Sullivan and Cromwell, John Ray III puts essentially all of the FTX international companies, the bulk of FTX, into bankruptcy. This was within hours, which is so fast. This is not normal. I've now talked to a number of people. It comes up in this paper. Like, it is not normal for a bankruptcy to go that quickly. Within hours, the company's been filed in bankruptcy, the international company. 3 days later, on November now 14th, 3 days later, pretty much all of FTX US gets put into bankruptcy by John Ray III and Sullivan and Cromwell. One company out of all of these doesn't get put into bankruptcy. Guess which one it is? It's LedgerX. LedgerX is like one of the only companies out of hundreds that exist within the FTX universe that is not put into bankruptcy. So LedgerX isn't put into bankruptcy. What's especially weird about this is LedgerX is one of, I believe, like 6 or maybe it's even 7 subsidiaries of another subsidiary within like FTX US land. And all of the other subsidiaries that LedgerX is like sister company to or whatever are put into bankruptcy. The other thing that's really weird, like there's no indication that LedgerX was in a better financial position than any of the other companies within the FTX universe. LedgerX had a European counterpart. So what LedgerX did for FTX US, which was to allow for certain kinds of derivatives trading and things, the counterpart in Europe was actually in better financial shape, arguably, than LedgerX was. But the European counterpart was put into bankruptcy and LedgerX was not. LedgerX just becomes this outlier over and over again. So what happens to LedgerX? Well, LedgerX is basically sold off very quickly after bankruptcies were filed for everything except for it. It sold off very quickly and potentially lost FTX a lot of money. It was sold off in essentially a fire sale, and the Wall Street Journal has reported that FTX lost about $250 million on the sale of LedgerX. Now, the truth is, again, like things are kind of messy, and it's very hard to understand exactly what LedgerX was worth, what was going on under the surface, but there were just a ton of lingering questions around it. So LedgerX gets out basically unscathed. It's sold for $50 million in like a fire sale to Miami International Holdings or something, which was a big shareholder of LedgerX before it got bought by FTX. And that whole thing is weird. Now, again, I think I said this earlier, there's not like a smoking gun per se in all of this, but there is a hell of a lot of smoke. And there's another thing, which is that on November 11th, which is the day that all of the FTX international companies were put into bankruptcy. Like everything is imploding. This is like, we are in the height of panic and war. The application that LedgerX had outstanding with the CFTC gets pulled back, it gets revoked, which is weird only in the sense that like everything that is going on, why is a priority, like why, who cares about this outstanding application by LedgerX to the CFTC? Also, by the way, if that application had been approved, it would have made LedgerX more valuable in a sale. So somebody was concerned about whatever was on this application that had been put to the CFTC, whatever. I mean, again, we don't know what happened. It feels very probable that like these misrepresentations have been made. Now somebody's going to figure that out. I don't know if this is Zach Dexter. I don't know if this is Sullivan and Cromwell themselves, but like at the height of panic, everything is going into bankruptcy. That was being prioritized. Again, further serves this point of like, what the heck? It's just weird. Okay, so all of this becomes the rationale, the argument for why Sullivan and Cromwell perhaps fought so hard to take control from Sam, to oversee this whole bankruptcy proceedings. In addition to the fact that they are making an obscene amount of money on this whole thing, it also, the LedgerX story paints a picture of like, this is a cover your ass scenario for them. And they are really trying to make sure that nobody figures out their own involvement in whatever happened at FTX. Okay, that's part one. Part two, though, the second question, the follow-on question to that is, okay, but why were they allowed to be the law firm overseeing this bankruptcy? Because it's not like they just get to self-appoint that. There's judges, there's a US trustee who looks over the bankruptcy process. Like there's other players in this scenario that are supposed to be there to stop this kind of impropriety. And this is where I found this article, this paper by Lipson and Skeel particularly interesting. So in this paper, Lipson and Skeel mention that on November 9th, Sullivan and Cromwell started to report things about FTX to government regulators and government officials. Now, I won't go too deep on this, but they even argue like some of that was potentially unethical. Like they were making certain representations. Sullivan and Cromwell were saying certain things to Sam Bankman-Fried that were very different than what they were saying to government officials and to regulators, which is weird because Sullivan and Cromwell represents FTX, and there's like code of conduct, ethics. I don't know how I would frame it, but basically like it was potentially very unethical the way they handled things with Sam. And I get it. It's like world's smallest violin. People don't feel too sad for Sam, which is why people probably aren't really upset by this. But like, I think as they put it in this article, two wrongs don't make a right. Like just because Sam messed some things up doesn't mean that this giant law firm has the right to behave unethically or violate like confidentiality with their clients or whatever, maybe was happening there. But the key to me in all of this is Sullivan and Cromwell is now reporting FTX to regulators. But not just that. Apparently, on November 9th, they also entered into or caused FTX to enter into an agreement with prosecutors to voluntarily produce documents. And this is really important because this agreement with prosecutors seems to be at the heart of why Sullivan and Cromwell was allowed to continue to be the law firm in this bankruptcy. Sullivan and Cromwell worked incredibly closely with the Department of Justice and the prosecutors who built the case against Sam Bankman-Fried for Sam's trial. The Sam Bankman-Fried trial happened so fast. I think in this paper by Lipson and Skeel, they even say, like, they describe it as like having broken the sound barrier in terms of like the speed at which this trial happened. Like it was within a year, Sam Bankman-Fried was on the stand being tried and convicted. And things usually don't move that quickly. The reason it was able to move so fast is that the prosecutors and the DOJ had just unprecedented amount of access to information about the internal workings of FTX. But not just that, seemingly also they had Sullivan and Cromwell and John Ray III helping these government prosecutors interpret what was happening internally within FTX. Like you think just like your random government prosecutor understands crypto and could like figure like there was this really, really cozy relationship. And on the surface, okay, fine. You know what? Like we want justice served. These people are in the controls at FTX. Of course, we want them to help regulators figure out what happened. The problem is a couple-fold. One, you have Sullivan and Cromwell may have also been implicated themselves. And so now they can be controlling what documents are actually being sent to prosecutors. So there's potentially something nefarious happening there. Again, you don't mind some sort of collaboration between whoever's running FTX after Sam and the prosecution, but you would prefer that to be somebody independent who has an incentive to be fully honest about what happened, as opposed to Sullivan and Cromwell, who arguably certainly did not have an incentive maybe to be entirely honest about it. But second of all of this was being billed to the FTX creditors, the FTX customers. So to break that down, Sullivan and Cromwell and John Ray III, who were helping prosecutors, spent hours and hours and hours and hours sending documents over, interpreting documents, working with prosecutors to build this case. And they wanted to be paid for that time. Okay. Who was paying for that time? The FTX creditors. Tens of millions of dollars were spent by FTX creditors, customers, to pay for Sullivan and Cromwell and John Ray III to spend all this time helping to build the case against Sam Bankman-Fried. And sure, if you were burned by FTX, you perhaps want to see some amount of justice. You feel like you want the people who are responsible to be held accountable for that. But would you rather just get your money back? Because frankly, that's how I would feel. I didn't lose money in FTX. I've lost a little bit of money in other crypto crashes. And like, just give me my money. It went beyond, my understanding is, it went beyond what is just a normal amount of collaboration. And it came at the expense of the FTX creditors. And that's, if you remember from the top of this, way back when I was explaining the whole theory of this, like the why you should care for all of this in many ways is because all of this is coming at the expense of FTX creditors. And so this is where we get to a very interesting dynamic. Why was Sullivan and Cromwell allowed to stay on as the attorneys, as the law firm in this bankruptcy? And one of the people who would have challenged this, who would have said that Sullivan and Cromwell should not be the attorneys in this case, it's ultimately determined by a judge, but somebody who would have been fighting and saying Sullivan and Cromwell shouldn't be this, is the U.S. bankruptcy trustee assigned to FTX. So in bankruptcies, you have this trustee who is a member who's within the Department of Justice, who is supposed to look after the bankruptcy process, to some degree look after the creditors. It's somebody who reports back to the court to say that everything is going fine and smooth and dandy and whatever with the bankruptcy process. The U.S. trustee in the FTX bankruptcy case did, in fact, oppose Sullivan and Cromwell as counsel. They said, yeah, Sullivan and Cromwell should not be the lawyers in this case. But interestingly, a few days before the judge was going to make a final decision about whether Sullivan and Cromwell could be the attorneys in this instance, Sullivan and Cromwell settled with the U.S. bankruptcy trustee on this. And I don't know exactly the ins and outs of it, but basically Sullivan and Cromwell made some more disclosures. They went into a little bit more detail about their past relationship with FTX, still, in my opinion, very much misrepresenting the depth of that relationship. But they still made some disclosures about that relationship. They made some more disclosures about that relationship, and the U.S. trustee dropped their objection to Sullivan and Cromwell being the attorneys in this case, which is weird because if you're just looking at it objectively, like clearly, even if there was no suggestion that there was anything improprietous about this, there are plenty of big, good law firms that can take on something like this. And that would have been more than happy to charge the hundreds upon hundreds of millions of dollars that Sullivan and Cromwell was charging to manage this bankruptcy. Why did the trustee drop their objection to them? And them dropping their objection is a big part of Judge Dorsey, I'm sure, the judge in this case, being like, all right, well, if the trustee doesn't have a problem with it, everything I'm seeing here doesn't seem like that problematic. Like, sure, fine, Sullivan and Cromwell, move forward. You can be the trustee in this. And by the way, this has happened now 2 times, which is also usually in a bankruptcy like this, certainly something of this size. If you look at comparable things like Enron or others, I mean, Enron was even bigger, but you would have an independent examiner. You would have somebody else who would come in to be a third party who'd be in the nitty gritty with everything. I mean, again, Enron had this to say, like, let's make sure that everything is proprietous, that everything, like, let's really investigate what happened here to the fullest extent possible. I mean, in the Enron case, some of the attorneys were found to also be culpable and to have had a role in the Enron situation. Like the same firm that helped Enron or any of the lawyers that were involved in Enron pre its collapse weren't then allowed to stay on and manage the process post-collapse. It didn't happen. So anyways, an independent examiner is often appointed and in fact is supposed to be appointed. And once again, you had the U.S. trustee, member of the Department of Justice trustee, object or say that they wanted an independent examiner appointed and then back down from that later on. And then kind of back down and be willing to just kind of be steamrolled by Sullivan and Cromwell. So if you're somebody who's been following this really closely, which most people have not been necessarily, but I have been, I've been talking to a lot of people about this. There's been this like, why? Like, why is this U.S. trustee seemingly just so asleep at the wheel? So what Lipson and Skeel say in this paper, which makes so much sense, who knows if it's true, but this is their theory, and it makes a lot of sense, is you have this very interesting dynamic, which is the U.S. bankruptcy trustee is a member of the Department of Justice. The prosecutors, who really want to look big and powerful and want a win in this case, are members of the Department of Justice. And you have Sullivan and Cromwell, who is working incredibly closely and being so helpful to the prosecutors in this case, because it serves Sullivan and Cromwell to get to cover their own ass and to build this relationship with the Department of Justice and to put all of the blame on Sam. I mean, it serves Sullivan and Cromwell in so many ways to super help the prosecution and to tell the prosecution the story that works best for Sullivan and Cromwell. So Sullivan and Cromwell don't care that they're charging the FTX creditors for this. This arrangement is working great for them. It's working great for the prosecutors because the prosecutors are going to be able to have this really swift, big win. They're going to look really good to the public, like they're cracking down on crypto crime and they're getting this case like done, set, and sealed. And so you have a conflict of interest because while the trustee, who's a member of the Department of Justice, if they were doing what was best and right for the creditors, would likely be arguing that Sullivan and Cromwell shouldn't be the attorneys in this case. You've got the prosecutors, who are also members of the Department of Justice, who really like working with Sullivan and Cromwell because they are very cooperative and very helpful. And so the question is, how does the Department of Justice handle these kinds of internal conflicts of interest where you have 2 different members of the Department of Justice who maybe want different things in an outcome? We don't know. And we don't know how it got settled here. But what happened in this case kind of looks like maybe what you would expect to happen in a situation where you have 2 members of the Department of Justice who have different ideals, which is you have the U.S. bankruptcy trustee. He pushes back. He says, we shouldn't have Sullivan and Cromwell in here. But then he gets steamrolled and he kind of just settles. And then he says, hey, we should have an independent examiner. But then he kind of just like doesn't push it too hard. It's like he's pushing enough to be doing his job, but he's not actually pushing hard enough to really be doing his job, which is servicing his fellow colleagues at the Department of Justice. I probably way over-explained that whole thing, but I think that's a really interesting theory and makes the most sense of anything because there is no other plausible explanation to me as to why the U.S. trustee who's supposed to be overseeing this wouldn't have pushed harder and would have just let Sullivan and Cromwell be the attorneys in this case. And of course, as I've now said, who gets screwed in this dynamic? The FTX creditors. They are the ones left holding the bill, footing the bill for all of this. There are 2 other things that I think it's really important to highlight here. First of all, it is not clear that FTX needed to go into bankruptcy at all. this has been something that has been talked about for a while now, but it's an even more salient talking point and question given the fact that FTX creditors are likely to be made whole. There's caveats around that, which I've talked about in past episodes, but FTX creditors are going to get a lot of their money back. And you've got John Ray III and Sullivan and Cromwell out there parading themselves like they are the returning heroes from war who have managed to get everybody their money back, when frankly it kind of feels like they were picking up money out of couch cushions. Like the price of crypto went up, like that was helpful. Investments that Sam made have done well. Like that was not all of them certainly, but some of them, like that was helpful. So anyway, point being, why did Sullivan and Cromwell move so fast to put these companies into bankruptcy and really mislead Sam in representations they made to him in order to get control of the company from him? Okay, but number two, this one's really interesting. Why hasn't Sullivan and Cromwell sued Binance? And this is something, I'm not going to go too deep in this. It's actually pretty quick to understand. This is something that, again, Lipson and Skeel raised that I hadn't thought about that I think is really interesting. And Binance and Binance's CEO at the time, CZ, put out a series of tweets that were very negative about FTX that precipitated essentially the run on the bank. The immediate collapse of FTX that happened in November of 2022, that was precipitated in large part by Binance and CZ. And so I'm not a lawyer, but what is clear to me from these pieces from Lipson and Skeel, who know what they're talking about, right, is that the harm that Binance caused FTX and FTX customers and FTX creditors was tremendous. And so in a normal bankruptcy proceeding like this, and even in this bankruptcy proceeding, right, Sullivan and Cromwell are going after all sorts of different parties to try and recoup money, to get whatever. They're trying to get money back for the creditors. And that suing Binance in a dynamic like this would be a very, very normal course of action to take. And it's strange that Sullivan and Cromwell has not sued Binance. Well, last month, it was reported that Sullivan and Cromwell are on a short list, are basically the top pick, which is apparently a technical legal term, or whatever, the monitor of Binance. Quick. Binance also has gotten in trouble with the U.S. government. Binance U.S. been in trouble with the U.S. government. The Department of Justice has apparently determined that Binance can continue operating under a monitorship. Like they have to have a firm overseeing all of their behavior or whatever. I'm probably botching the exact precise definition of all this. Anyways, the point is that it's going to be a very lucrative position. It's being reported that's whatever firm gets that job will make a lot of money. And Sullivan and Cromwell is on the short list of that. So Sullivan and Cromwell is on the short list to be the monitor for Binance, which presumably they couldn't do if they were suing Binance in their role and their capacity as the counsel for FTX's bankruptcy. So the argument here is, well, they haven't gone after Binance, which would actually be the thing that is best for FTX creditors. They haven't gone after Binance because, frankly, they want the very lucrative position and appointment of Binance. And by the way, who makes the decision about who's the monitor of Binance? The Department of Justice. The Department of Justice makes that decision, who's now all cozy and happy with Sullivan and Cromwell because Sullivan and Cromwell helped them get the win in the Sam Bankman-Fried trial. And it just all feels unsurprising and disappointing at the same time. But it's human nature. I mean, look, there's conflicts of interest in places. It has to get resolved some way. This happens to be the way it got resolved. To me, it's frustrating because to me, what I would want prioritized in all of this above anything else are the retail investors, the people who lost their money keeping it with FTX. That is who I want to be prioritized. And that they have, of course, because they don't have a voice in this, they are the people who are being prioritized the least. Let's end here with some choice quotes from Skeel and Lipson in their paper. I think some of these are really interesting, pretty scathing. And again, this is coming from legal professionals. First, quote, "The debtors curiously failed to pursue causes of action against those who may have caused the debtors the greatest harm, in particular, Binance. In many cases, these decisions appear more consistent with protecting or advancing the interests of Sullivan and Cromwell than the interests of the debtor's estate." Again, it would be in Sullivan and Cromwell's interest to be appointed the monitor of Binance. So maybe they're not going to go sue Binance, or it's in their interest for the to be cozy with the Department of Justice. So they want to stay on, whatever, you get the point. Okay. Another quote here, quote, "Similarly, FTX has never sued Binance despite the catastrophic harm it caused, perhaps because Sullivan and Cromwell has quietly been awaiting an appointment as that company's monitor. These and similar decisions suggest that concerns about Sullivan and Cromwell's private interests may have outweighed the public interest in maximizing creditor recoveries in Chapter 11. And finally, and this last quote speaks to this whole independent examiner thing. Sullivan and Cromwell fought tooth and nail to not have an independent examiner, even though that's in my view, clearly what would be in the best interests of the public. Quote, indeed, as discussed below, Sullivan and Cromwell's resistance to an examiner suggests that they may have sought to suppress evidence about their conduct before and at the commencement of the case. Moreover, Ray and Sullivan and Cromwell have made a number of seemingly value-impairing decisions, which are better explained as efforts to protect Sullivan and Cromwell than to maximize the value of the FTX bankruptcy estate, which we discuss in part 5 below. Anyway, folks, that is our episode for today. I'm really curious your perspective on all of this. I will link also below to the article, the paper by Lipson and Skeel, if you're interested in reading more about that. I will also say, I don't know exactly when this episode is coming out. It is likely coming out right around the time that Sam is getting sentenced. I didn't reference that because I'm recording this episode a week before his sentencing, so I don't actually know the outcome of that. So sorry for that if that's a glaring omission. Anyway, I love hearing from you, so please do comment below, like, subscribe to the channel. Thank you for making it through this particularly long episode, and I will see you next time.